Assalamu alaikum wa rahmatullah. Today we are talking about a person who has asked me in the comments a question or an opinion. We can say it that when a tenant vacates a rental property, the landlord has the right to inspect the premises for any damages beyond normal wear and tear. If significant damage is discovered after the tenant has left, the landlord can pursue the legal action to recover the cost of repair. In such cases, the rent controller no longer has jurisdiction because their authority is limited to the disputes arising during an active tenancy. Once the lease ends and possession is handed back, the appropriate legal remedy is suit for damages in the civil court. When we are talking about the steps to take, first one is to gather the evidence, documents all damages through photographs, videos, and witness statements. Secondly, review the tenancy agreement. If it includes a clause holding the tenant responsible for property damages, this strengthens your case. Third one is legal action. File a suit for damages in the civil court, outlining the estimated financial loss and supporting it with the evidence. And fourth one is security deposit deduction. If any security deposit was taken, it can be adjusted against the damages before initiating legal proceedings. When we are talking, if we may talk about the preventive measures for landlords, we would say that always have a written tenancy agreement with clear terms on property maintenance. Secondly, conduct a thorough inspection before refunding any security deposit. And last one is take prompt legal action to avoid complications in claiming the damages. If I say in conclusion, the landlords have a legal right to seek compensation if a tenant causes damage to their property. The correct form for this claim is a civil court, not the rent controller, and strong documentation is a key to the successful case.